Hi, this is Erick Becker from Cummins White, and we're going to be discussing today meal period practices to prevent liability after the Donahue decision. Donahue was a recent California Supreme Court decision that provided clarity to employers on what you need to do to protect yourself from liability for meal period violations. And in my practice, I probably see allegations of meal period violations more than any other claim from employees. So this is a really, really important point for employers to take to heart. The Donahue decision gives you a roadmap to make sure that you're doing everything possible to prevent your business from having liability for these meal period penalties. But before we talk about Donahue, it's important to first make sure that there's an understanding regarding the basics regarding meal periods here in California. So the basic requirement is that every non-exempt employee must have a meal period available to them that starts within the first 5 hours of work. So as an example, if an employee starts work at 7 a.m., they must start their meal period by 12 p.m. because 12 p.m. is the end of the 5th hour of work. Now, it's important to recognize here, the employee doesn't have to finish their meal period by 12 p.m. They only need to start their meal period by 12 p.m. The other issue for meal period compliance with respect to the second meal period is that if an employee works over 10 hours and doesn't waive that second meal period that they're entitled to, or they work more than 12 hours and then the second meal period is automatic, that second meal period must start before the end of the 10th hour of work. The employee must be able to take that meal period, for instance, if they start at 7 a.m., and they work till 7 p.m. and they take a lunch break from 12 to 12:30, that second lunch period has to start by 5:30 p.m. The reason it's 5:30 as the end of the 10th hour of work is because the first meal period from 12 to 12:30 does not count as hours worked. Now, the other requirement for meal periods is that whichever meal period it is, the first meal period or the second meal period, it must be 30 minutes in length. The employee is entitled to take the full 30 minutes. It can't be cut short by the employer. If your business does not comply with these meal period requirements, there's two potential avenues for liability. Number one, each employee is entitled to a penalty for each day that they don't receive a compliant meal period. And that penalty is 1 hour of pay at their regular pay rate. In addition, an employee can file what's called a PAGA action, Private Attorneys General's Act, where they can seek penalties against the employer beyond the 1 hour of pay for each pay period where meal periods weren't provided. And those PAGA penalties can add up to significant liability. So in my world, I see a lot of claims for meal period violations from individuals asking for those penalties on a class action basis on behalf of all employees seeking that 1 hour of pay for each day they didn't receive a meal period, or in a private attorney's general action, or a combination of all three. And that's where the significant liability can arise for the employer. Now, prior to Donahue, there was kind of the seminal case in California regarding meal periods, and that was the Brinker decision. This again was a California Supreme Court decision, and it came out in 2014. And Brinker said an employee is not required to take the meal period that is provided by the employer. In other words, the employer is not automatically liable just because an employee fails to take a meal period. So if the employer can at least prove that they made a meal period available, And if the employee voluntarily chooses not to take that meal period or to take their meal period late after 5 hours of the workday, or they take less than 30 minutes, then the employer is not liable. And Brinker was seen as a victory for employers trying to avoid liability in these types of cases. But the Brinker decision left a lot of questions unanswered. And a couple of those questions were answered in Donahue. The questions left unanswered by Brinker were, number one, can meal periods be subject to rounding? Rounding is where in the timekeeping system, you either round up or round down. For instance, for meal periods, if an employee took a 25-minute lunch, you round up to 30 minutes, and in the timekeeping system, it would show that they took 30 minutes for their meal period. Similarly, if they took more than 30 minutes, you would round down to 30 minutes, and the employee would get the benefit. So Brinker left that question unanswered. Can you round on meal periods? The second question left unanswered by Brinker is, does the employee have to prove that they were denied a meal period, or is it the employer's responsibility to prove that the meal period was voluntarily skipped or taken late? Because again, Brinker said, look, the employer is not liable if the employee voluntarily skips the meal period. But Brinker left unanswered how that burden of proof falls. Does it fall on the employee or does it fall on the employer? And lastly, Brinker left unanswered the question of whether, if the time in and time out for the meal period isn't recorded, the employee fails to punch in and out or doesn't write it down, or for whatever reason, there's no record of the meal period, is there automatic liability for the employer for meal period penalties or pocket penalties? Now, those questions, as I mentioned, were answered in this recent California Supreme Court decision, Donahue versus AMN, which came out in February of 2021. The bad news for employers is that the decision in Donahue made compliance with meal periods a little more challenging. And let me explain why. First of all, the Donahue court said when it comes to rounding of time, whether up or down, meal periods cannot be rounded. In other words, you cannot have a system that automatically rounds meal periods up if the employee took less than 30 minutes. The meal period must show on the time record that the employee took the full 30 minutes in order for it to be a compliant meal period. Secondly, the Donahue court said employers are not automatically liable if meal periods are not recorded. So this is in line with what Brinker said. And this was the part of Donahue that was actually a win. In other words, if the employee fails to punch in and out, that doesn't automatically mean the employer is liable for meal period penalties. However, what the Donahue court said, and this is the key thing that the court found, there is a presumption that the employer is liable for a meal period violation if a meal period is not recorded in the time system or on some sheet of paper, or if the meal period is short, meaning it's less than 30 minutes, or the meal period is taken late, meaning it's taken after the first 5 hours of work, or for the second meal period after the first 10 hours of work. So the presumption is that the employer is liable, meaning the burden of proof is on the employer. And that makes it more challenging to comply with the meal period requirements. Now, what the Donahue court said was the employer can rebut that presumption, but they have to have evidence that employees were provided the opportunity to take a meal period and voluntarily chose otherwise. So that evidence could be a compliant meal period policy that says employees are entitled to take meal periods and here's the rules for taking them, but that's not enough. What Donahue said was the employer also has to have evidence that it was the employee that voluntarily chose not to take their meal period, or to take a short meal period, or to take a late meal period. So where does that leave employers when it comes to compliance? Well, here's the things that you need to make sure that you're doing to protect yourself from liability for meal periods. Number one, it is important to record the exact time that the employees started and ended their meal periods. In other words, it's not sufficient to simply write down 30 minutes on a timesheet for the meal period, or to have some sort of automatic recording of the meal period in the time system, where every day the employee has a meal period from 10 a.m. to 10:30 a.m. The only way you can prove that a full 30 minutes was taken, and was taken in a timely manner, taken in that first 5 hours of work, is to have either a punch in the time system from a time card or a computer system, or the employees writing down the exact time they started. Hey, I started the meal period at 10:31 and I ended at 11:02. So that is a very, very important point to have compliance, so that you can prove that you, in fact, provided that meal period. And if the employee chose not to take it, they did it voluntarily. The other thing that you can do is have some sort of system to create evidence that a missed short or late meal period was voluntarily. For instance, a lot of the big payroll companies are now instituting in their payroll systems, timekeeping systems, a drop-down menu that automatically appears when an employee did not take their meal period or took it late. And then the employee can select an option that either they chose voluntarily to take that meal period late or to skip the meal period, or they don't tick that box, and then that would indicate that the meal period penalty is owed. If you don't have that type of sophisticated timekeeping system, you certainly can create a form that each employee would have to complete for each non-compliant meal period, with a set of boxes to indicate why they didn't take their meal period either at all or late, or they took less than 30 minutes. And that way you'd have that evidence to prove that it was voluntary. Now that creates a lot of paperwork and record keeping, but it's the only way to have that evidence. Lastly, if you can't get verification from the employee that they skipped the meal period or took it late voluntarily, then you should have some sort of system that automatically pays the employee that meal period penalty. Again, a lot of the big payroll companies are now putting that in their systems, where the meal period penalty is automatically paid. And that is at least one way to prevent the liability from accruing over a 4-year period for missed meal periods. The other thing that it's important to do is at regular intervals, whether that's weekly or monthly, you need to have someone auditing the time records to make sure that you're not missing meal periods, that people are not failing to punch in and out, that people are not taking that meal period late. And if you audit those records and you see that there's violations, you can either obtain a voluntary verification from the employee that when they missed that meal period or took it late, they did it voluntarily, or retroactively pay the penalty. And again, that is a way to not only have evidence in case you do have a lawsuit, but also to limit your liability. It's a lot cheaper to pay employees the penalty than to end up in a lawsuit where you've got the potential of having to pay big penalties and attorney's fees to both the defendant and the plaintiff. Now, the automatic meal period penalty does not completely eliminate liability. Even if the meal period penalty is paid, there's still that possibility someone can bring a PAGA lawsuit. So it's very important that you do whatever you can to get the paperwork or computer records in order to demonstrate that when an employee did not take a compliant meal period, they did it on their own voluntarily. And that's the way you can avoid having that huge liability hanging over your business's head, because we're going to continue seeing class and PAGA claims based on meal period penalties, particularly after this Donahue decision. So to recap, it's really, really important to make sure that you're doing regular auditing of your timekeeping records, and that you have these systems in place to either compensate employees or for meal period violations, or get voluntarily verification that they did so on their own, and that the employer did not require them to skip their meal period or take a late meal period. I'm Erick Becker from Cummins White. If you have any questions about this topic or any other employment-related topics, you can always reach me at my email address, which is ebecker@cwlawyers.com, or at our main phone number, 949-852-1800. Thanks for watching.